The judges of the Court of Appeals of the State of Oregon. I'll go ahead and bring up counsel for our first case. Counsel, can you see and hear the panel?
I can see at least. I haven't heard anything yet.
I should start my video at this point.
Yes.
Yeah.
Yeah, there we go. Great. Our first case this afternoon is A179834, Jordan Swartz versus Washington County. Mr. Mansfield, when you're ready, we're ready for your argument.
Thank you. May it please the court, I'm John Mansfield. I'm county counsel and representing appellant Washington County in this matter. I've already asked the clerk for the 5 minutes for rebuttal and assume that's okay with you folks. This case, Your Honors, is about the plenary authority of an Oregon home rule county to pass ordinances for the health and safety of its citizens. Here, Washington County, which is an original home rule county, acting as the local public health authority, used its home rule power to pass an ordinance banning flavored tobacco, Ordinance 878. Trial court found as a matter of law that this ordinance was preempted by SB 587. The trial court's opinion is erroneous for at least three major reasons. First, the trial court did not cite or apply any Oregon preemption law, not the Constitution, not a case, not a statute, not an administrative rule. Second, the trial court did not recognize that Washington County as a home rule county has plenary power to pass laws for the public health and safety. Third, the trial court erred because it did not find that the legislature had an unequivocal intent to preempt local tobacco regulation. Your Honors, Washington County will ask that the court reverse the judgment of the lower court and remand it with an order to enter summary judgment for Washington County and against plaintiffs. The first error that I mentioned is fairly straightforward. There's simply nothing in the opinion that serves the basis of the judgment of this case that cites any case for or statute or constitutional provision for the standard to apply in a preemption case like this. I'll note that Washington County cited all of the major cases and including the ones that we cited in the briefing in this case. One of the most important cases, of course, on this would be the Road Valley Sewer Services v. Phoenix case, where the court, of course, finds that there has to be an unambiguous intention to preclude local governments. So we'll discuss in a minute that it's clear that the trial court never cited or applied Oregon law. I should also point out that he didn't inherently cited that he didn't go about applying the tests that are in the city of LeGrand or Rogue Valley sewer systems or any of the other cases. And so essentially we were flying blind on the law here. The second error is that the trial court failed to consider that that Ordinance 878 was adopted by Washington County under its home rule power to adopt health regulations. It doesn't need another basis on which to stand. Now, ordinarily, the Supreme Court has made it clear that ordinarily, when a petitioner's arguments implicate the authority of a city, we begin with the authority of such local governments under the home rule provisions of the Oregon Constitution. That's the Gunderson case, 352 Oregon 648. Here, there can be no doubt that Washington County had inherent authority to adopt 878. Again, the Supreme Court, I'm sure you're familiar with, but has made it clear that home rule is the authority granted by Article 11 and Article 4, and Washington adopted its own charter in 1962, and like most home rule charters in this state, the county has authority over matters of county concern to the full extent as allowed by the Constitution and laws of the state, as fully as if each power comprised in that general authority were specifically granted by the charter. It's also important to note that when the Oregon legislature exercises its preemption power, it does so unequivocally. An important case for that, we've been coming back to many times, is the Rogue Valley Sewer Services case. In that case, Chief Justice Balmer spent several paragraphs discussing how you can find whether there's an unambiguous intention to preempt. And I'll just Judge Balmer, speaking for the court, Chief Justice Balmer, speaking for the court, makes it clear that while the legislature has sometimes said express preemption, they have had other times when they have used similar language, even though it doesn't say preemption. For instance, it notes that the courts have expressed their disapproval of completely local laws in equally clear terms. It's also important to note that in this case, the sewer systems case, they found no preemption. This was a case where the local regulatory scheme, had to do with sewer systems, regulated less extensively, the state sewer system regulated less extensively than the local ordinance. That's pretty much what we have here. We have the state law, SB 587, which is less extensive than the local ordinance, especially in the area of flavored tobacco. So again, I think the Rogue Valley Sewer System case is very important on that. I also think it's that the third error is worth focusing on. The trial court erred in making no finding that SB 587 expressed an unequivocal intention to preempt. Here again, the Supreme Court says, quote, "A party that challenges a home rule city's authority as preempted by state law is required to show that the legislature unambiguously expressed its intent, a high bar to overcome." I kind of like to think about this as the show me rule. The plaintiff who wants to prove preemption has got to show where the statute says in unambiguous terms that the legislature intended to preempt. My apologies to anyone from Missouri here. Nowhere does the trial court address whether the legislature had an unequivocal intention. And in fact, the record actually shows that the court believed that there was no unequivocal intention. After summary judgment, after the plaintiffs were granted summary judgment and got a permanent injunction, they moved for attorney's fees against Washington County on the theory that preemption under SB 587 was so clear that defendants' failure to automatically stipulate to a preliminary and permanent injunction against the ordinance was in, quote, bad faith. In the fee hearing, the trial court found that Washington County had no bad faith and that a fee award was unwarranted because the issue of preemption was so close that it could have gone either way. Here's what the judge said in open court on the record. Quote, "The reason the parties ended up in litigation in this was because of a state law that was so poorly written that both of you," meaning both counsel, "blew it up on the board and told me it stood for absolute proof of your position, the rightness of your position. Anytime parties who are directly opposed cite the very same language for their position, that is not good law. That means it is open to vastly different interpretations." In effect, what the court found that there was not a clear intent. So again, we're very we don't even need to get into the interpretation of what SB 530. I can never get the numbers right. The state law here in this case means. I'd be happy to analyze that, but again, we don't even need to go to the state law and analyze it because, to begin with, we have an inherent power under home rule authority. The second, there's been no showing of an unequivocal intention to preempt. And while the plaintiffs have got several theories regarding implied preemption, none of those cases, they have yet to cite a case that shows applied preemption in this particular situation. For
So
instance,
let me ask counsel, and I laugh because this is more of a rhetorical question than legitimate. It's more of a softball. How did you lose this in the trial court?
well,
So what I'm wondering is, you haven't talked about Section 17, but if I understand your argument correctly, your home rule county, LeGrand case and Tom Ballmer's case make pretty clear you've got plenary authority. So then I looked to Section 7, and this is more of a counsel, sort of an early warning for respondents counsel to help me with this. Section 17 of the session law goes out of its way for the legislature to say that the local body has the authority to enforce, for purposes of public health and safety, additional standards. So how did you lose this? I ask myself, well, it's simply because the state does the licensing just to authorize users, and that was enough to preempt? Is that how you lost it?
Well, thank you, Your Honor. You're not the first person to have asked this question, shall we say. I have to hand it to my able colleague on the other side. This is an easy case, and one of the reasons, when I say easy, I think a comparison of a case that we submitted from the Multnomah County Circuit Court, authored by Judge Schwade, which held the exact opposite on a very similar statute, is even more evidence. Now, of course, that's another circuit court case and not a case that controls here. But the reasoning in that is exactly, and in fact, it was the same. It was a different county counsel, but it was the same counsel here was the lead lawyer there. I think that there was confusion about, I think the biggest problem was that the court did not start again from the law. When you don't cite the basic law in the case, and again, it's uncited. I've read that opinion dozens of times, and there's nothing about the preemption law, and there's also nothing about home rule county. And by the way, these are brought up in our lower county, our lower our briefs before the trial court as well as here. These issues have all been live, and again, I can't tell you what the trial court was thinking other than that. But I'm not trying to avoid any questions, but I do think that when you don't start from the basics, you can find yourself ending up in the wrong place. And that's what I think happened here, because there was no citation of any the Ballmer's case, of the sewer case, the LeGrand, the Gunderson case, any of those cases that make it very clear that there's a preemption. We certainly argued it. The court instead turned to Section 17 and didn't even address our home rule argument, as you can see.
Can I ask you just, sorry, Judge DeVoria, do you have another question?
No.
Can I ask you just, so the third point you raised about Senate Bill 587,
Mm-hmm.
So is it your understanding that this is a standard? Section 2A says enforce pursuant to an ordinance standards for regulating public health and safety. Is this a standard?
This is certainly a standard. It was it is. I think it's important. This gets confusing a little bit here because it's not. I do admit it's not the clearest drafting, but it regulates. First of all, we're a local public health authority. That's no doubt. It is an ordinance. It was enacted by the governing body, which is the Washington County Council. Those are undisputed. It is a standard for regulating the sale of tobacco products for purposes related to public health and safety. There's been a debate about whether regulating is the same, allows the power to ban. Does the power to, is this a standard or not? Because, and this is I'm presaging one of my colleagues' arguments, which is this is not a standard because your banning is not regulating. I just want to point out that we have submitted a case that I didn't frankly read until after this had been briefed, that makes it clear that the Oregon law is as follows. This is the Northwest Advancement case. The lower court in our case held that the power to set standards did not include the power to prohibit certain products under Oregon law. The Northwest Advancement case, which this court heard in 1989, was about a state agency that was trying to determine suitable employment hours for minors. And they decided that in some situations there were no suitable hours. In other words, they just eliminated, which is similar to what we did. We, rather than just regulating some of this tobacco, we
Counsel, pardon me for interrupting. Is that cited in your brief?
It's cited in we filed a memorandum, an additional memorandum.
Thank you. That's all. Thank you.
Thank you. And so at any rate,
our questions used up most of his rebuttal time.
Yeah, we could give you some more time. Why don't you finish up your question, then we'll work the time out for answer.
I'm happy to answer any more questions or just close up if you'd like.
Why don't we give you then? So we'll give you 3 additional minutes on rebuttal, and we'll add 3 minutes on to Mr. Aiello if he wants that to even the time out. I think maybe we'll give you 3 minutes and 40 seconds to if he wants that. So we're even. Thank you.
Thank you, Your Honors.
So look at that organized. Great. So, Mr. Aiello, we're ready for your argument when you're ready. Thank you.
Good afternoon, Your Honors, Counsel. May it please the court. My name is Tony Aiello Jr., and I represent plaintiffs in this matter. This case presents a case of first impression to this court concerning Senate Bill 587. As the court knows from briefing, the court will soon have the opportunity to get a second impression under similar but not identical facts arising out of Multnomah County. The questions in this case really boil down to the following. Can a county nullify the statewide, state-issued, shall-issue license, or is such nullification preempted? Plaintiffs believe that question can be decided by asking whether Senate Bill 587 preempts a total prohibition on the sale of any and all tobacco products and inhalant delivery systems by a local public health authority, thus nullifying the state's statewide, state-issued, shall-issue license entirely. If the answer to that question is yes, then there is no reason why a local public health authority could not partially ban the same products and only partially nullify the state license. If the answer to that question...
Pardon me, I'm going to nitpick here, just devil's advocacy. Are your clients able to sell ordinary tobacco that's not flavored?
Yes.
Then how then does it nullify the state license to sell tobacco?
That's Your Honor, that's why it's helpful to consider a total ban. What defendants are arguing is that they can enact a total ban under the home rule plenary authority. Now, they argue differently before the trial court, but there's no reason looking at Senate Bill 587 or defendant's home rule authority to conclude that a total ban would be disallowed while a partial ban would be allowed. And even if there is such an intention, where is the line drawn in the bill? So could they ban everything except for hand-rolled cigars? Is there a line in the bill somewhere? There's not. There's nothing, and defendant's counsel could not identify it before the trial court.
Okay, mind you, this is not necessarily what I think. I just have my devil's advocate hat on. Can they totally ban all impurities and toxic substances from tobacco products that are consumed? Can they totally ban impurities and toxic substances?
No, they cannot ban products that are legalized, licensed, and expressly authorized to be sold by the state of Oregon.
But can they ban toxic substances in tobacco products? If they say we won't permit mercury to be in snuff.
No, not if it is banning a product. Now, I've got a different role for what the local public health authority can do, and maybe I can jump there.
Can they ban substances within the product?
No, not if it results in banning the product. No.
Not if it results in banning the product that's allowed by the state.
Correct. It is expressly legalized, authorized, and licensed. Yes, Your Honor.
So if it's legal for the product to be sold under the state statute with mercury in it, mercury is okay.
Correct. Inadvisable, of course, but
right. I get it.
But it would be legal to sell under the state's license if it fits the definition under ORS 431.175 of the definition of tobacco products and inhalant delivery systems adopted in Section 1 of Senate Bill 587.
Well, under your theory, Mr. Lido, is that the county cannot regulate any product that is specifically authorized by the state statute.
No, they can regulate it under Section 17.2a, which
regulate it to place and time of sale and things of that nature, but not what's in it. That's your point.
Correct, Your Honor.
Okay, got it.
Because the result, if the county were to say, for instance, you cannot sell tobacco with flavoring additives added to it, the result of that would be banning a product. So I think it's helpful to consider a total ban, and below at the trial court level, defendant conceded that a total ban would be disallowed. Now, much was made in defendant's briefing about whether or not tobacco products are legalized through this. Plaintiff's argument is that they are. They are legalized to be sold because all unlicensed sales are illegal now. So what we have here is the state expressly saying, if you get this license, you can sell these products as we have defined. And that's what my clients are doing. Now, I'd like to turn briefly to the Northwest Advancement case. Northwest Advancement, and just the site for your honors is 96 or app 133, 1989. That case does not stand for the proposition that to regulate includes the power to prohibit. The case was explaining an overstatement by a party of another holding. That case is Oregon Newspaper Publishers Association v. Peterson, 244 Oregon 116. That's a 1966 case. And what the court explained is that in the Northwest Advancement case, it was the power to determine suitable hours, not the power to regulate those hours that confirmed the ability to prohibit. So you can regulate the hours on the one hand, and you can determine suitable hours on the other hand. So if you can determine suitable hours, what the court said is that if you can determine suitable hours, then you could determine that 0 hours are acceptable and regulate thusly. Plaintiffs would assert that that the Oregon judiciary and the legislature routinely distinguishes between the power to prohibit and the power to regulate. Just some statutes here would be ORS 166.171, ORS 166.173, ORS 227.500, ORS 471.730, and ORS 527.722. And so if regulate means prohibit, then all these statutes where the word regulate and prohibit are both included are superfluous.
Counsel, let me ask you, does ORS 431A 218 sub 2, also the section 17 of the session law, regulate so as to allow a local public health authority, the county, to regulate, and I'm quoting from section 2, to regulate for purposes, quote, for purposes related to public health and safety, so as to require all cigarettes to be filtered or low tar?
No, because that would be prohibiting product. Section 17(2)A, and I've lost track of my notes here, does not confer the power to regulate. It confers the power to enact standards for regulating and qualifications. And the word standards for regulating has not been used in an Oregon statute nor defined by any Oregon appellate court. To say that it means to regulate would be adding or subtracting words to the statute.
But aren't you adding words to the statute? Because Section 17 says that a governing body means what it means, and each local public health. And I don't know where you're drawing the distinction between regulate and ban, because I don't see those terms in subsection 2. It says the authority may enforce pursuant to ordinance for purposes of public health or safety, their local ordinance.
But that, with respect, Your Honor, that's not what the statute says. It says enforce pursuant to an ordinance enacted by the governing body of the local public health authority, standards for regulating the retail sale of tobacco products and inhalant delivery systems for purposes related to public health and safety. It does not say to regulate. It says to enact standards for regulating. Now, there wasn't a ton of analysis before the trial court on what that means, but what plaintiffs have argued and what plaintiffs believe the trial court adopted is that a standard refers to how something is done. So, for instance, defendants have argued that 17(2)A means nothing if you cannot prohibit. That's untrue. They can require electronic age verification. They can require age verification with every single transaction. What they cannot do is ban products that are otherwise duly licensed by the state. I'd like to get to defendants' home rule authority because it seems like defendants have moved off of Section 17(2)A a little bit at oral argument. So defendants' supposedly plenary home rule authority conflicts with and is incompatible with state licensure generally, as well as specific sections 5, 17(2), 17(7), and 17 subsection 7, and section 18 when read together. So section 17(2), if defendants' power to regulate, to enact ordinances is unfettered under its home rule authority, then section 17(2) is a meaningless redundancy. There was no reason to put it in there. And it is section 17(2) would amount to nothing but a limited partial definition of what defendant's home rule authority supposedly is. So that those two, home rule authority and section 17(2) cannot be harmonized. I would direct the court to Fairbanks versus Boley, 323 Oregon 88. The pin site is 94. It's a 1996 case. It is cited in the brief, and it stands for the proposition that if two statutes cannot be harmonized, the specific statute is considered an exception to the general statute. Moreover, this specific grant of authority came later. And I would cite Preble versus Centennial School District number 287 and State v. Vetter. Both are cited in the brief, and they stand for the proposition that where two statutes are irreconcilable, the earlier yields to the later. The state's creation of a statewide license and a specific and limited grant of authority indicates the legislature's intent to pull back some measure of authority from localities. This was demonstrated through Section 5, which created a statewide, state-issued, shall-issue tobacco retail license. They define what a licensee may do with such a license. They also, in Section 17(7) and Section 18 together, read that the state intended its licensure to be exclusive, subject to the limited and inapplicable exception under Section 18. Defendant relies on its home rule authority under Article 6, Section 10 as its source of authority for enacting Ordinance 878. Again, it's helpful to consider here whether defendant can, under that authority, can prohibit the sale of tobacco products and inhalant delivery systems totally. So, then the state's licensure means nothing. My clients went out, got a state license, and are authorized expressly by the legislature to engage in conduct, which is now prohibited by Ordinance 878. Which brings us to the issue of conflict preemption. Conflict preemption under La Grande Astoria is when a local enactment is found incompatible with state law in an area of substantive policy, the state law will displace the local rule. Applying that test in a case called State versus Tyler, which was decided by this court stated, quote, when a statute permits actions that an ordinance prohibits or prohibits actions that an ordinance permits, the legislature has preempted the ordinance under conflict preemption. Here, Ordinance 878 prohibits conduct which is otherwise permitted and expressly licensed by the state. In doing so, it nullifies the state's licensure. And if defendant's interpretation is adopted, there's nothing stopping a local public health authority from nullifying the state's licensure entirely by enacting a total ban. And here, again, why I think it's helpful to look at a total ban is because it's logical to consider the extent of the parties' respective arguments. Additionally, there is no line drawn in the statute. So if this court were to decide that a partial ban is allowed, but a total ban is not, where's the line? Could they ban everything except for filtered cigarettes? Could they ban everything except hand-rolled cigars or pipe tobacco? Plaintiffs would assert no. Other portions of Senate Bill 587 where there's conflict are Section 17.5A. In Section 17.5A, the legislature indicated that where it acts, it intends its standards to be enforced consistently statewide by the Oregon Health Authority. Among the standards, yeah.
On that point, as to statewide governance, do you read the Oregon statutes as permitting the state to regulate so as to eliminate the sale of flavored?
I think we lost Mr. Mansfield, so maybe we'll.
Oh, he's here.
Is he here?
Yeah.
Maybe it's. Is it me?
Yeah.
Yes, you have disappeared.
I'm here. I can hear.
Maybe,
I can hear
maybe it's
everything.
me. Okay,
You went blank.
Yeah,
I did?
we can.
I haven't had any break in the.
Okay, you're back, Mr. Mansfield. So I was. Can you see me?
I can't see you.
Okay,
I can
I'm
see your
here and
name.
I can hear everything. So maybe we'll carry on. If I disappear, maybe let me know.
We'll
I'll
yell
try to
right
rephrase
now.
the question briefly, Mr. Ayala. Thank you for your patience with us and the technology. Mr. Ayala, does the state have the authority under statute to regulate the sale of flavored tobacco?
Does the state? Of course, they issued the license. They gave the permission to. They've banned tobacco sales, except for if you have a state issued license. So of course the state could decide that it wanted to, other than if there's some other challenge, I'm not thinking of a constitutional or otherwise that may come up under Senate Bill 587. Of course they could ban it.
So they could ban flavored tobacco.
The state of Oregon, absolutely.
The state of Oregon.
Yes.
And does that play into your preempt the field argument?
So the preempt the field argument, I think is really what the legislature's indicated is that where it was 17.5A is that where they act, they intend the law to be applied consistently. So absolutely, if the state were to ban licensees from selling flavored tobacco, that would have to be applied consistently throughout the state. Some other county could not, unless they have their own licensure, allow flavored tobacco sales contrary to state law.
Yeah, I could see, taking off the devil's advocate hat, that if this legislation by the state said the state is going to regulate, including choosing which products may or may not be sold, that would be an argument you might have for preempting the field. But for the fact that when I go back to subsection, or it's 218 sub 2, there's a carve out that says local bodies may also regulate for purposes of public health. But I don't want to go back to the arguments you've already addressed about you distinguish between regulating and not banning. But I will ask it in this way: does the language that you see that authorizes the state to regulate the sale of flavored tobacco by prohibiting it also rely on the word regulate?
No, the legislature, the state of Oregon doesn't need to be authorized by Senate Bill 587 to enact a ban. The state has that power already.
Where?
In its power as the state of Oregon. I mean, it's their license. So they can amend this statute to not, so they can amend, I believe it's section 1 defining inhalant delivery system and tobacco products to not include flavored tobacco. Absolutely.
Oh, but what I was asking, does it now do that?
No, it defines the definition under ORS 431A.175 of tobacco products and inhalant delivery systems is quite broad.
Okay, now I can hear. Sorry.
It's
all on my end. Okay, thank you. Sorry.
It's a very broad definition. I'm running out of time here. I want to get just two other points on the record really quickly. Defendant has argued that the legislature does not authorize the sale of all tobacco products with this Senate bill. The legislature routinely does that, authorizes conduct by prohibiting the unlicensed conduct. ORS 9.160 subsection 1, ORS 676.520, ORS 744.053, and ORS 471.282. I'd also point to the Winters v. Basalian case, 152 Oregon 578. The pen site is 587 to 88. It's a 1936 case relied on in LeGrand v. Astoria, and it stands for the proposition that when the legislature has expressly authorized conduct, their speed limit, local laws to the contrary are preempted, even if stricter than the state speed limit.
Great. Thank you for the argument. I don't think we have any further questions. So maybe we'll give Mr. Mansfield another 38 seconds. So it'll be 3 minutes and 38 seconds to even the time out.
I think that's fair, Your Honors. Thank you.
Okay.
Thank you, Your Honors. Appreciate it. Let me go back to 17 subsection 5. That has nothing to do, that doesn't talk about standardizing. This says the state standards established by state law and rule and regulations are administered consistently through the state. That's not about local. The idea that means that all local regulations are going to be the same is frankly not tenable. I'd like to point out that there's an entire section called local regulation, section 17, local regulation. Each local public health authority. The primary defining aspect of this is that this isn't something they threw in. This is a whole section about that, about local regulation. And it's also interesting that how expansive this definition is. First of all, it's standards for regulating. And by the way, we don't accept that standards for you adopt an ordinance and it sets a standard. I think it's a clever argument that my opponent's making, but there's nothing like that in the law. But at any rate, the 2A says enforce for public health and safety in addition to the standards described in paragraph B. What is paragraph B? These are state law standards that the local health authority can enforce as well, but they have a but for, which is that they have to make a deal with the Oregon Health Authority. And then, of course, the third is in addition qualifications for engaging in the retail sale of tobacco products or inhalant delivery systems that are in addition to the qualifications in Section 5. Section 5 is the license section. They're in addition to this. This is expansive. Again, we don't need to go there because we already have the home rule power to do this. I also want to make it clear that although Mr. Ayo claims that the licensing law legalized tobacco has been legalized for 100 years. It's tobacco. There was no legalization doing. What happened in this law was that they're now licensed. There are not, and again, this is a licensing law that also allows local regulation. But the idea that there was some affirmative legalization of, for instance, flavored tobacco, like that there is some right for that. Flavored tobacco is not mentioned anywhere in this, nor is it in the legislative history. What we have here is a general statute that has a couple of aims. One is to have a state licensure law that applies throughout the state. Second is to have local regulations. That's what we have here. And again, this is to say that having the Washington County doesn't have a plenary authority to do that. It completely inverts the state of home rule law. My time is up. We had just asked that the trial court's opinion be reversed and that it be remanded for entry of summary judgment for us. Thank you, Your Honors.
Great. Thank you to you both for the argument. That case is submitted, and we're ready for our next case.
Thank you.
Thank you, Your